Okay. Hello, I'm Max Green. I'm gonna make a short video, or I don't know how short it'll be, a video on the subdivision control ordinance draft that's being proposed for the zoning meeting on the second, which is at 6:30 on Tuesday. I have a little bit of background in what the zoning ordinance require. I mean, the county had this document here for years. Since the beginning of time, they were given it that by KK, the first consultant they had, on what's required when doing these subdivision control ordinances. I've read the planning guides here. This is from cover to cover. This is 2011, and every 5 years they come out with a new one. This is 2017. I read it too. This is 2022. I've been through this one as well to see what actually the zoning ordinance require, and where the county's not in compliance. I'm going to start off with, I'm going to give you a code, but don't worry about the codes for now. We got a list of codes later on to let you see what everything's going on. But start with Indiana Code 36-7-4-702 says a subdivision control ordinance must specify standard specifications. The minimum width, depth, and lot area. You check out this new subdivision control ordinance, it has no depth in there whatsoever. They're not in compliance to start with. Public lays, widths, grades, curves, and conditions of the subdivision, public ways, and current and planned public ways, and also the extension of water, sewer, and other municipal services. This new subdivision control that they're proposing said, well, you got to talk to somebody else and refer to an outside document to get any information. Where this previous subdivision control ordinance, which was written by an attorney that the county has right now, has everything that the state requires in it, and the only thing it needs to be changed on is going from a major and a exempt subdivision to a major minor, and the changes in the exempt subdivision. And one of the changes they did make is they went down to 1 acre instead of 2, which is a good thing for the county, because we've been attending his meetings. I've spent 15 years taking off time work to come to attend these meetings. And my wife spent 20 years in the commissioner meetings, taping them, videotaping those, and we've not seen a rash of problems with the 2 acre minimum being the topic of appeal. So that 1 acre was a good move on their part, but they need to come back and redefine their ordinance to meet the state standards. That's what we're asking for. And there's only a few differences in here. One of the things they complained about was that driveways with more than one house on them. But their previous subdivision control ordinance required no more than 10 driveway accesses per mile. The county had forced people into doing this, and now they're going to complain about what they've done and call them non-compliant and all this other crazy stuff. It's not right, and it ain't fair. They need to go back and include this new changes from their old ordinance to put into this one, because this existing ordinance has all the required dimensions and stuff. The radius is 75 foot, and the grades not to exceed 15%, and everything that the state asked for. It even has in the drainage water that you can't build up on your new property in such a way as to change the drainage to run off on the neighbors, to say, well, how does it affect the neighbors? And if it's not specified in a concrete form what they have to abide by, they can say it don't make any difference, and you still have to pass them. So that's the big argument over this. And you say, well, why is this important? Well, it's important because the state of Indiana says it has to be on one document. It has to be one freestanding document with concrete specifications on what you need. And you say, well, why is that important? Well, you just look back at what they did, not just because of state law, but in this last year, the county took to court over a zoning issue, and they lost in court. Judge Medlock said the document 2020.101 and 2021.03, which were declared to have no effect by the Judge Medlock. This is important because this is one of the documents that the county would refer to when they're trying to say this is what we're doing. And they're referring to an outside document that won't stand up in court. There's no reason to reach outside of to do a document that's not legal and to get in trouble over it. Now, why is that important? Well, their attorney, after they lost in court, instead of going in front of the board and saying, hey, we lost because we didn't do everything in compliance with the state law, we're going to go back and dot our I's, cross our T's, and we're going to have a public hearing, and we're going to pass this thing so it can be enforced in court. But instead, they just kept their mouth shut and let the public believe these ordinances were still in effect, even though legally they weren't. That's not fair to anybody. And then you wonder, well, why ain't somebody said something? Well, we tried. We tried to participate in this and get them to do right all along, but when we tried to participate last year, we asked for the Freedom of Information documents on all the stuff that they'd passed in the previous years in their zoning board, the documents that was supposed to be ready to be prepared for this super ordinances. Well, we were told they didn't have them, even though they passed them in public meeting. And then turned around, so we called Jackson County, the guy in Jackson County who was writing on the new ordinance. He said he didn't want any input from Washington County residents, don't call back. So that kind of put a squash on that too. So we really didn't have a good place to go here on that. I'm going to, let me stop for a minute. All right, I took a quick break. Now I'm going to come back and I'm going to give you all these county or all these state laws that I got the information on, and what you double check what I'm doing. We're going to put this information up there where you can see it and read it. But to access this from the state of Indiana itself, you type in your Google search Indiana codes, and then for instance 36-1-8-10. And what's going to kick up is going the Indiana code concerning party affiliation on these boards that require no more than 3 of the same political party and things like that. The previous law said before they got appointed, their party affiliation was determined by the last primary election they served, they participated in, whether it was a Democrat ticket in the primary or a Republican ticket in the primary. That was their party affiliation. Now, the state's changed the law that after June 30th of 2023, you have to participate in 2 primaries to determine what party affiliation you are, to prove that you're not just jumping the fence and you're still got too many of the same party on a board. That's 36-1-8-10. Now, the next, I'm just going to go down the whole list of what they've got into. 36-7-4-208. That's the Indiana code in the zoning that says no more than 3 of the same political party on this zoning board. That's where they've got in trouble for a long time, because they've had, they know the law existed, and they've had members back in 2016, 9 years of the 15 years this board's been in existence, they had illegal membership, because they would call Mark Hartman a Democrat all along. He was always a Republican, and he even ran in the election as a Republican candidate. They knew what they was doing. I didn't realize it at the time, and I used to be on the BZA, and when I finally figured out they wasn't complying with state law, I went in front of the commissioners in 2022, and I went in front of the zoning board twice in 2022 and asked them to start complying with state law, and they refused to do so, and that's why I resigned from the BZA. But I know enough about this stuff that I want all the public to see, and we tried to get somebody to do something about it, and nobody ever would. Okay, the next one's going to be 36-7-4-213. They must appoint one of their board members to serve on Salem's board. They did that one time in 2011. David Hoare, and he served one meeting, and they didn't go back. All these years later, they've never reappointed anybody else to follow the state statute, because it's just too easy not to follow state statutes. and get away with it. 36-7-4-216 shall determine valid membership. They must. This is one of the things the attorney brought up just a month or two ago when she was looking at the ordinance and said, well, one section says may and the other says shall. And the difference in the law is may means if you feel like it and shall means you have to. This 36-7-4-216 says they had to determine whether their membership was legal or not. That's when I was complaining about Andrew Catt, the same as Mark Hartman, did not own property or reside within the jurisdiction of this board. And also the party affiliation part of it. But when I asked the board to look into it and consider that, they refused to do so. And the only answer I got was from Daniela Walker, who said, we feel comfortable with the board we have right now. Well, when you're in the Good Old Boys Club, you're always comfortable with the Good Old Boys Club. Okay, 36-7-4-216, it also says you must own property or reside within the jurisdiction of the board. That's where living in the 2-mile fringe of Salem, the unincorporated area they claim, is not in the jurisdiction of the county's board. That's why these members were illegal. They did not own property or reside within the jurisdiction of the board. I'll go on to 36-7-4-902. No more than 2 of the BZA members may also be on the zoning board. Well, they messed that one up too, because this is all after we'd had a discussion with their attorney on who can and cannot serve on this board, these boards. And what they ended up doing was 36-7-4-905. No elected official, no elected office holder can sit on the BZA. But instead, the county's attorney and the attorney for the board allowed a sitting commissioner, an elected official, to be put on the BZA. That made the 3rd member. And then, to top it off, here's the confession she made. Here's what it shows, the membership there. It shows what she's claiming as the membership on the BZA. Clearly you can see 3 of these members also served on this board. And one of these members on this board is also the sitting commissioner, Todd Ewan. That's just part of what went on, and nobody does anything about it. Nobody cares. But you'll know anyway. Look for 36-7-4-218. Staggered term limits. When these people were appointed to these boards, in the beginning of time, the first one was for 1 year, the second for 2 years, the third for 3 years, and the last 2 for 4 years. You say, well, what's the big deal? Well, the idea is you have continuity in your board. And the purpose for that being that you'd only lose 1 board member every year, or 2 on the 4th year that had to either be reappointed or find a replacement. Now, what's supposed to happen is one of these people quits, whoever they put in here is required just to serve whatever's left on their term and then be reappointed or somebody else appointed. But the problem is the county didn't keep track. They have no clue when these when these boards expire. And why is that an issue? Well, 5-14-9 beginning and expiration dates are required on all public notices and agenda. If you look at what the zoning board's been putting out there, they've got their beginning dates, but the ending dates are all the same year. They're not staggered terms. They don't have a clue when the staggered terms are, and they figure, well, we just throw something at the public and it don't have to be legal. They just won't know the difference anyway. Well, there is an issue for it, and there's a reason for it. Here we go with the 5-14-1.5-2.9. They got to include their website on the notice for the agenda. You've not been seeing that going on yet either. So that's just some more stuff that they're just fast and loose with the state laws. They don't have to think they have to do anything. And the kicker part is, if you read the book, Indiana Code 36-7-4-1614 D4, about the only way the county gets overturned in court is if they fail to follow all the procedures in accordance with the law. And that's what they did to lose in court on the previous case last year, And every time they go to court, they lose because they've not followed all the procedures. They don't want to have legal membership. They don't want to go through the trouble of doing it legal. They'd rather bluff the public into submission. Because they know if they threaten you got to get a lawyer, a lot of people ain't got the money and say, oh, well, forget it. But if you get a lawyer, you'll beat them. Because this Indiana code says so. 5-4-1-1.2. You must take the oath of office within 30 days. And if you don't comply with this, the office becomes vacated. This is one that Adam DeFore brought up in the commissioner meeting because he had seen where it had come up in Jefferson County, and it was an issue, and they said he knew for a fact they hadn't been taking the oath, and he asked that they start doing it right and reappoint the board and do it legal. Well, the commissioners didn't want to do that. Tony Caldwell wanted to do that. He said, well, let's make a resolution. But he didn't have to make a resolution because the state law already said the state seats are vacated. What they needed to do was reappoint the people they had on the boards and get them their oath within 30 days and be happy with it. The problem is they got one board member that changed political parties. She's no longer eligible for reappointment, and they can't tell whether her last appointment was for 7 months, 19 months, 23 months. They don't know how much was left on that term that she's trying to fill out. So they have an issue with that, and they can't prove what the real deal is. 36-7-4-702. That's the one I stated for where the state law requires the lot depth and the grades and etc. They don't even want to follow their own state law. Even paying an outside consultant to write this stuff up, they don't want to do it. They want to take shortcuts. They don't want to do it in a legal manner. And if you want to look at the Stephanie Rocky's provided with us with the when we asked for it, the voting records to go along with this state law, Indiana code, to see how these people participated, to see whether they were actually truly Democrats when they called them Democrats or not. And you can do that too, but you got to find out that all these board members they had in the past, a lot of them didn't meet the state's criteria. Mark Hartman, he wasn't a Democrat and he didn't own property there. Andrew Catt didn't own property or reside within the jurisdiction of the board. Tom Day, he was a Democrat, but he didn't own property or reside within the jurisdiction of the board at the time. He just owned property in the city of Salem's 2 mile fringe. John Cantrell in a 2 mile fringe. Deidre Miller was on the board for a long time as a Democrat, but she started voting Republican pretty regular in the primaries. So it makes it tough when they don't follow the laws that's on the books. And when I asked for I got this confession here because I complained about the Andrew Catt not meeting for different criteria. And when she laid it out here for me, she said, in here it says, according to Stephanie Rocky, Indiana is a non-declaratory state when it comes to political party affiliation. Well, that is true, but the Indiana Code 36-1-8-10 specifically says these boards that have political affiliation requirements actually applies. So if you switch parties every cycle, you'll never meet the criteria to be put on one of these boards. And that's part of the issue. You can't sidestep and say, well, it's just too hard to follow state law. Is not a reasonable explanation for why you don't require all your members to meet the criteria that the state says. Well, part of this, you say, well, why is this so punky in particular? And but as you read these state codes, you're going to see that they're progressive in nature. Like 208 starts out as you got to raise a resident in an unincorporated area of the county, and then 216 says you have to be a resident in an unincorporated area of the county and within the jurisdiction of the board. It's just like you got to be 18 years old to vote. And if you want to vote in Indiana, you got to be a resident of Indiana. And you want to vote in the Salem School District, you have to live in that district or you can't vote in that district. That's what the state says the criteria and they're just sidestepping everything. So, well, I'm 18, that'll be good enough. I'll vote in 4 states at the same time. So it's crazy. And the reason this board needs reeled in is because whether you realize it or not, this board can become a taxing agent. It has the authority outside of the caps on your home owners, your property taxes, outside of the local income tax. This board has the authority to tax, and it needs to be doing stuff legal before they get to that point. And you say, oh, well, the public has a right to speak at all these meetings. Well, the public does have the right to speak at all these meetings, but check this out. The public has the right to speak it in some cases, but in the subdivision control, the law says that neighbors with objections are irrelevant, so long as they meet all the criteria and standard. So by them telling you, oh, well, you got an opportunity to come in front of the board and you got a right to speak, the state law says you got a right to speak, but they don't have to listen. Why you still got the opportunity to tell somebody they will listen to you, you best be on top of it. You best be telling them they're not going to do me that way. And this ordinance actually is one of the smoother of what they got going on. But the problem is, back in September last year, they were already discussing solar and wind energy, and they come up with what criteria they thought they needed to have for it, and they was going to package that up, and they was going to send that forward to Jackson County. Well, instead of having anything to do with the solar, which turned into be an issue this year, the only thing we got back was an ordinance that said you can't fly a kite in Washington County. They got so far off track, it's just not even, without a permit.
Well, without a permit. We'll do something funny.
Yeah, without a permit. So it's just so far off track, they're out of control. They need to be reeled in to the point, because if they get this easy one passed and they don't have 500 people show up like they was before, then they're going to go back after the other stuff. So take it as what it is. I've did the best I can to inform the public on what's going on and what they've been doing illegally for years and continue to do for years. And if you can live with that. And another thing, we did try to reach out and contact everybody that had been elected in the state of Indiana on the ballot from the last election cycle. We contacted the governor's office, the lieutenant governor's office, the attorney general's, Aaron Housen's office, everybody, and then nobody would uphold state law. Everybody said, well, we don't uphold state law. That comes from the governor of the state of Indiana when he was a U.S. senator. I don't uphold state law. And apparently he still don't as governor of the state of Indiana. So you take it as that. Have you been voting for the right people? Are you sure the people you have in office got your back or not? Take it as that. Good luck with that. That's our new political party
Of Washington County.
Of Washington County.